somebody identifying your body, because you never know what you're going to get when you're taking drugs. And find you guilty, revoke, sentence you to 5 years in the prison. Give you credit for any time served. There's to be no unsupervised contact with minors, no residing in households with minors, therapeutic community. And I will. All right, court is calling 2020 CR 7507 State versus Desiree Garza. Can I have parties announced?
Derek Emmons from Miss Garza.
And are you Ms. Garza?
Yes, ma'am.
All right, did you review the document entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision with your attorney? Did you understand it?
Yes, ma'am.
Are you the same Desiree Garza who was placed on deferred adjudication in 2020 CR 7507 for the offense of possession of a controlled substance, penalty group 1, 4 to 200 grams on May 4th, 2021 for a period of 6 years? Is that you? All right, state.
Violated condition number 2, on or about the 22nd day of August 2025 in Bear County, Texas. The defendant, Desiree Garza, did then and there fail to submit to drug testing as directed by the court. Court officer, supervision officer, and or a duly authorized agent of the court in violation of condition number 2.
How do you plead to that? True or not true?
Sure. Violated condition number 2, on or about the 18th day of November 2025 in Bear County, Texas. The defendant, Desiree Garza, did then and there fail to submit to drug testing as directed by the court. Court officer, supervision officer, or a duly authorized agent of the court in violation of condition number 2.
How do you plead to that? True or not true?
Violated condition number 2, on or about the 9th day of December 2025 in Bear County, Texas. The defendant, Desiree Garza, did then and there fail to submit to drug testing as directed by the court. Court officer, supervision officer, and or duly authorized agent of the court in violation of condition number 2.
How do you plead to that? True or not true?
Sure. And finally, violated condition number 2, on or about the 30th day of January 2026 in Bay County, Texas. The defendant, Desiree Garza, did then and there fail to submit to drug testing as directed by the court. Court officer, supervision officer, and or a duly authorized agent of the court in violation of condition number 2.
How do you plead to that?
Sure. State will waive the remaining allegations.
Any objection to the waivers?
No objections.
All right, and that's for
Four.
number 2s.
Yes, ma'am.
All right, did you understand by pleading true to violations 2, 2, 2, and 2, the court can find it true, grant the motion, find you guilty, and sentence you up to 20 years in prison and up to a $10,000 fine? Knowing that, do you still wish to plead true?
Yes.
Court will find 2, 2, 2, and 2 true. Is there a proposed agreement?
Yes, Judge, the proposed agreement is to grant state's motion, enter an adjudication of guilt, revoke, and sentence to 4 years in the prison. The state will also take into consideration clause number 2026 PF 14573.
All right, did she do any inpatient treatment?
She did, Judge.
Okay. All right, so why is she not testing? This is her 3rd MTR. So can somebody explain to me? All right, if you want to explain, you'll have to raise your hand and I'll take you under oath. Do you solemnly swear affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand. State your name for the record.
Desiree Garza.
Ms. Garza, the judge asked you a question, why you were not submitting to the UAs. Could you answer the judge why you have not submitted to the UAs or why you missed them? What happened in your life, why that happened?
I was going through a lot at the time and I knew I was dirty and I'm not gonna lie, I knew I was dirty. I didn't.
So that still doesn't explain why you didn't report, because you have responsibilities. So you were just not following through on anything. And if you've been in inpatient treatment, they've talked to you about what you need to do in order to stay clean and sober. You just choose not to do that. So I don't know why I should give you 4 years and why it shouldn't be more. So does anybody have an answer for me?
Judge, I understand the court's position. She has been a safety. There's been some expense that the state has put out there for her rehab. Obviously, addiction is a difficult thing people deal with, and it's something she has dealt with. One of the recommendations in the probation officer's file was revocation, of course,
Mhm.
as well as, safety special needs.
Mhm.
I guess that's a separate safety program from what she's done before.
Mhm.
I've explained to her judge that on a revocation, she's gonna be repeated from here on out. She'll have a PDC trip.
Mhm.
She's not over probation if she ever gets in trouble again. She just assured me that she has a daughter that started, that's in the military, is about to graduate. This boot camp, I'm assuming. She wants to try and put this behind her. Obviously, her track record is not really showing that she's capable of doing that as of yet. We understand that, Judge. We're asking the court to consider even the 4 years TDC. There's a lot of bite to that because she will be a convicted felon now. She understands that. So she'll try and put this behind her as quick as she can and move forward in a positive direction.
And is this her first felony? And the reason why I asked that, because the plea bargain agreement, the state was silent on your application. And so the court gave you deferred adjudication. And at that time, they were asking that you be sentenced to 2 years in the prison.
Based on looking at the history, Judge, I do not see any, there's not county convictions. I do see, however, there have been several arrests that have been.
All right, this is what the court is going to do. The court is going to grant the motion, find you guilty, revoke, sentence you to 5 years in the prison. Give you credit for any time served. There's to be no unsupervised contact with minors, no residing in households with minors, therapeutic community. And I will give you credit for any successful inpatient treatment completion.
Thank you, Judge.
All right, did you, yes.
She has a monitor on her ankle as well still. I think the court ordered it from what she shared with me. It's RMS
They
monitor.
got her they have her with a monitor and while she's at the jail?
Yes, and I've never encountered that before, Judge, but the deputies told me that it happens more often than you thought. I thought I could just call pretrial GPS and have them come remove because maybe they didn't need the monitor for someone else yet. But she's sharing with me that is actually through, which I think is something you might have ordered on her last MTR.
Okay,
You had ordered it when I got released from safety, like relapse.
all right.
Yes.
Ms. Abrams, did we order a monitor for her?
Judge,
Are they letting you charge the monitor at the jail? All right,
And it was partially done, at her last.
all right. I'll order removal of the monitor.
Thank you, Judge.
All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it? You have a limited right to appeal. That right to appeal is as it relates to the allegations in the motion, not the fact that you're on deferred adjudication. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question about what that is, you will need to speak to an attorney. Do you understand?
Yes.
And also, you all are taking something in consideration, correct?
yes, Judge, I emailed the intake.
All right, so, and also for the record, taking in consideration 2026 PF 14573. All right, we can go off the record. Here's the thing. If you don't change your life, you know what's going to end up happening? You're going to end up going back and forth to prison, or you may end up somebody identifying your body, because you never know what you're going to get when you're taking drugs.
Yes, ma'am.
When you're released from, take advantage of the therapeutic community. The therapeutic community doesn't increase the time you're in custody, but it's designed to help you. So what will end up happening, I've ordered it, they're going to see it on the judgment, but I don't have jurisdiction to force you into that program. So you're going to have to ask for it as well. When you're released from prison, the first thing you need to do, go to Lifetime Recovery, go to felony drug court. And this is why I'm suggesting you go to felony drug court. Felony drug court will have all the resources for you to get you in an inpatient treatment facility. Do you understand?
Yes.
All right, I don't want to read about you on the news, okay? All right, good luck to you.
Maybe excuse church.
Yes. Who's next? Are you all ready to proceed?
No, we're asking for a continuance, and let me tell you why. First off, I've just been appointed and second of all, I'm not appointed, hired. And, he has a case, tomorrow in Uvalde on a forgery of financial instrument that he was indicted in, and the arraignment is tomorrow.
Oh, they're not gonna take him from here until this case is resolved. Like, they're not gonna transport him until this is resolved.
So what's gonna happen to the arraignment?
Oh, I have no idea. But they're not doing anything there until this is resolved.
Well, I think we still need a continuance so that we can see what we need to do to work out both.
All right, have you conferred with the state on this? Yes. All right, so I require that everybody confer.
Oh,
Okay, all right, thank you.
well, I don't know, what do you think, Brian?
Oh, you just,
What are they gonna say? Yes, no,
State.
whatever?
Yes, sir.
can you speak to him on Jesse Gonzalez? It's on page 9.
Thank
All
you,
right,
Judge.
Thank you, you're welcome.
See, there you go. Have a seat. Second chair.
All right, anyone else ready?
Yes, that's page 3, first one. For Yvonne Watson. That's the one I'm supposed to log in on.
They're not on.
No, okay.
Okay, who's next?
That's all I have for now. Sir.
All right. And do you- Okay, that's fine.
Right.
Sorry, Judge, I had him confused. It's the other way around.
Oh, what? All right, all right, Jesse Gonzalez.
I'm sorry.
I'm sorry,
I'm
yes.
not used to the,
Oh, that's okay.
I've known this kid his whole life. I've known his father, his whole family.
All right, so my
Fine.
understanding, it's okay. So my understanding on the motion to revoke, it's just failure to report.
Correct, Judge.
All right, so we'll set it for contested.
Yes.
Yes, it's not true. Yes,
All right.
thank you.
Ms. Ferguson. Is Norm over there?
So they'll send us a setting in the mail? or
No, I'm
something?
gonna tell you what your date
Oh,
is right
that'd be
now.
awesome. Where did?
Yeah.
I brought,
Yeah.
oh, it's right there.
All right, this is coming back on May 21st for a contested hearing.
We have a later date,
No, that's it. Okay,
May
21st,
1st at
21st.
21
Yes,
at 9.
yes.
Got it.
All right,
Okay.
thank you.
Okay, well,
You're welcome.
okay.
All right, thank you.
Can we get a bond?
Oh, you have to file a motion and then I'll hear it.
Okay, what is, this is his third MTR. Is there any hope?
Oh, yeah, I mean, he's on deferred adjudication. Yeah, he's entitled to a bond.
Oh, okay.
Yeah.
So just file a motion.
File a motion and I'll hear it.
Okay,
And usually they don't object to notice. So
okay,
you can file it, we can put it on the docket for tomorrow. But if you not, wait, tomorrow is Wednesday, correct? Yeah. So we can put it on the docket probably for Thursday, but you'll need to make arrangement with the coordinator to put it
Okay.
on the docket.
all right. Thank you.
Thank you. All right, Lindsay. Somebody is zooming in. And what's your,
Yvonne Watson.
all right, Yvonne Watson, is that you?
She said I can put it on the docket for.
Yes, ma'am, I'm here, present.
So your video?
Yes, ma'am.
Good morning.
That's
How
okay.
you doing, Stephanie?
I'm doing great. How are you doing? Thank you. All right, so I think we've come up with a plan to help you. And when I say we, I mean probation, your attorney, and all of the medical personnel. So there's a couple of things that your attorney is going to want to go over with you today.
Yeah.
And if you can talk to him about the information they're requesting, his brother may or may not have access to that or may have it. Because I think his brother may be his guardian. I'm not 100% sure. And so he may have that information.
I can check, Judge, and if not, I will contact the jail liaison and maybe UHS once I have this to see what we can do. Hopefully Ms. St. Clair can call me back, because I was trying to see if she's ever screened someone in custody. And then we'd also have to check with SB and see if Mr. Payne can be transported directly. If he can't be transported, maybe that needs to be his brother or possibly might be some members of an assist, but ideally, that's where she just said.
Okay. And then I don't know if the jail did any type of assessments.
They took the initial screen, but I think the most current and the one that they would want, because it's asking for daily updates in here, would be UHS, because they're the one giving you medication.
All right.
So maybe with this, I can get some.
Okay. All right. Awesome.
I'll check this.
Oh, thank you.
You.
Well, thank you. And you're looking better too. We're going to try to get you out as quickly as possible. Okay. All right. All right. Thank you, sir.
I'll look in the probation file to see what we have, but
Let's go back.
there are certain medical things that I would not be able to release unless I had some type of subpoena or court orders.
Okay. I'll do a court order. I'll do that right now.
Thank you.
And then you'll get the release. So let me do that right now.
Thank you.
All right. Thank you. All right, Mr. Seeloff, are you ready?
Yes, Your Honor, we're ready. He wants to make an announcement to the court.
All right, and what's your client's name?
Eric Guzman. He has two charges, possession, by a felon and, a drug case.
All right, yes.
I would like to retain the word.
All right, if you want to hire an attorney, then Ms. Ferguson. Set this in 30 days. Mr. Seeloff, you're still the attorney.
I understand.
Unless he hires one.
I gave him a card of Mr. Young. He is very good. And so hopefully he can, make some arrangements with him.
Right. What date, Ms. Ferguson? June 4th.
June 4th.
Right.
I don't need any further notification, right? I guess.
All right, thank you.
June 4th.
Thank you.
Okay, 6, Linda Fargo.
Linda Esparza? Yes.
Back in November. I had not seen her, and it's my understanding she picked up a new case in March.
Mhm.
I was under the understanding she was out on bond. She is not. She's incarcerated, and so they were gonna bring her up, and she just had a medical episode, so
Okay.
she's on her way to the hospital. I was asking for a reset.
All right. Ms. Ferguson, on this case, I'm going to give you a date in June, but if you want her brought back sooner or you think she can be brought back sooner, just let us know. I'm going to put it at the end of June.
That clears me of everything, and I'll try to get a hold of her when she's out of the
All
hospital.
right, Ms. Ferguson, end of June? June 29th. All right, June 29th.
Can I just check Tuesday?
Is that a good date for you?
Yes, Your Honor, perfect.
All right, we'll see you back then.
Thank you.
You're welcome.
Maybe excuse?
Yes.
You're back.
Thank you.
Yes, I'm working on two, please.
All right, thank you. You said June 29th, right?
Yes, sir.
Thanks.
Yes, ma'am. Thank you. No, that's, yeah, that's only what I had today. Thank you.
Is Michael Craig on the docket today?
Yeah, you can push through the bottom.
Michael Craig?
Let me find.
All right, they said you paid all the restitution.
Thank you, Judge.
Come.
And we can
Here.
take these.
Yes. All right, you're welcome. Have a good day.
See ya.
Bye. Who's next?
We're just waiting on the police.
All right, thank you. Jonathan Estrella Rodriguez. Estrella. All right. Jonathan Estrella Rodriguez. Thank you. Still not here. Donald Crawford. Armani Bullocks.
Doing all right.
All right. So where are we on contracts and all of that?
Contract has been submitted today, Your Honor.
Okay. Norm, I need a final PTD date.
June 4th.
All right, June 4th. Thank you for dressing appropriately for court. Once you sign the reset form, you will be excused. All right, thank you.
Thank you, Your Honor. May we be excused?
Yes.
You can have a seat, sir. Thank you.
Yes.
This dismissal needs to be done from yesterday.
All right, thank you.
Thank you.
Working on one more people.
All right, thank you. All right, who's here on Stephen Lamone? All right, thank you. Probation, this is an application. Hello. All right, court is calling 2026 CR 003283 State versus Stephen Lamone. Can I have parties announced?
Rene Munoz on behalf of Mr. Limon.
And are you Mr. Lamone?
Yes, ma'am.
Counsel, have you received all discovery? Did you review it with your client?
Yes, Your Honor.
Mr. Lamone, did you review the application for community supervision with your attorney? Did you understand it?
Yes, Your Honor.
Did you review the true bill of indictment with your attorney? Did you understand it?
Yes, sir.
Counsel, do you waive the reading of the indictment?
Yes, Judge.
State, are you proceeding on the indictment as presented? Court will find that the state is in compliance with discovery. Mr. Lamone, did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
You're charged with driving while intoxicated, third or more. That's a third-degree felony. Range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine. If you have a plea with the state, the court does not have to follow your plea. If the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses. The state will call in the right to remain silent. By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case?
Yes, Your Honor.
Counsel, has your client been able to provide you with any defenses?
Yes, Judge.
Do you believe he has a rational as well as a factual understanding of the charges against him?
That is correct.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Mr. Lamone, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Anyone promise you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, Your Honor.
If you're not a U.S. citizen, by entering this plea, you will be deported, denied naturalization, and re-entry. Did you understand?
Yes.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, Your Honor.
According to the plea, punishment is to be assessed at 8 years in the prison. There's a $0 fine. The state is recommending community supervision. This is running concurrent with 2025 CR 007431. Restitution, if any, and 2-year driver license suspension or affidavit of non-driving. Did you understand that to be your plea?
Yes, Your Honor.
Defense state?
Yes, Judge.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes.
By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand? Any such motions?
Judge.
Outside the agreement, the state is requesting that your community supervision be for a term of 5 years. There'll be a TAP evaluation, 200 hours of community service restitution, 10 days in the Bear County Jail, participation in the felony drug court, DWI intervention, VIP live, and ignition interlock for half the term. Did you understand those were recommendations from the state and the court does not have to follow those recommendations?
Yes, Your Honor.
To the offense, how do you plead? Guilty, not guilty, or no contest?
Guilty.
State any evidence.
No objection.
All right, did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, and most importantly, there will be no live testimony? Did you understand?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence state's exhibits 1 and attachments and review the same. All right, after reviewing state's exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty and the court will find you guilty. Are you proceeding with sentencing?
Yes, Your Honor.
And I'm assuming he's already been accepted into felony drug court?
He has, judge, in that case that is to run concurrent is also a case that he's currently on.
All right. So here's the thing. And I know I probably told this to you before when you were placed on probation. You can't drink alcohol, period. And if you continue the way you are, one, you're going to end up destroying your liver. And then you're going to be on some site asking for somebody to donate a liver. You're going to destroy your kidneys, or you may end up killing someone. You understand? And I understand that you have military service, but any issues that you have that's related to that, you're going to have to start addressing those and not through alcohol, because otherwise it's not going to end well. You understand?
Yes, sir.
All right. This is what the court will do. The court is going to sentence you, as previously stated, the court, I'll state you may be excused. As previously stated, the court is going to find you guilty. The court is going to sentence you to 8 years in the prison, suspended and probated for 5 years. There's to be regular random UAs, regular reporting by Zoom or in person, proof of employment within 45 days of release, no employment as a home health care provider or with minors. He's to remain in custody counsel until released by felony drug court.
Yes, Your Honor.
There's to be a 2-year license suspension. This is to run concurrent with 2025 CR 007431. 200 hours of community service restitution. I'm going to deduct an hour for every sober support meeting that's completed. Field visits 1 time per month until further notice. DWI intervention, DWI education, VIP live, restitution, if any, to Paul Sparks. Ms. Ferguson, I need a restitution date. State, how long will it take to get restitution?
But 2 weeks is fine.
All right, can you set it 3 weeks? All right, that'll be May 26th for the restitution hearing. And I assume they said in here that they would allow an affidavit of non-driving, but what I'm gonna tell you, if you have access to any vehicles, like it's in your parking lot, I don't care if it's somebody you're living with and it's their vehicle, then for the court, you have access to that vehicle and that vehicle will need ignition interlock. You understand? All right, so
Your Honor, one quick question regarding the restitution hearing. If he is in an inpatient facility, can he appear through Zoom?
yes. So that's ignition interlock, full term, or affidavit of non-driving with proof of no access to vehicles. And probation, I know it's hard for people to prove a negative, but once you all go to the home, you'll be able to see if he has access to vehicles. So it's ignition interlock full term or affidavit of non-driving with proof of no access to vehicles. And that will be with a portable alcohol monitoring device. 10 days in the Bexar County Jail as a condition of probation. Probation, is there anything else? Is there anything else you need from the court to be successful? You're welcome. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it? Because this plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. Do you understand? All right, so here's the thing. You got to figure out why you're using, and you've got to figure out what works for you to maintain your sobriety. And if there are people who are around you who realize that you shouldn't be drinking, and they tell you, oh, it's just one drink, those are not your friends, and you're gonna have to cut them off. Your sobriety needs to be your number one priority, okay? All right, good luck to you. Okay, 6 CR 0022796 State versus Kilpatrick. Can I have parties announced for the record?
Jonathan Alvarado for the defense.
And are you Ms. Kilpatrick?
Yes, Your Honor.
Counsel, have you received all discovery? Did you review it with your client?
Yes, Judge.
All right, did you review the application for community supervision and deferred adjudication with your attorney? Did you understand it and sign it? Did you review the true bill of indictment with your attorney? Did you understand it?
Yes, Your Honor.
Counsel, do you waive the reading of the indictment?
We do, Judge.
State, are you proceeding on the indictment as presented?
Yes, sir.
Court will find that the state is in compliance with discovery. Ms. Kilpatrick, did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places? You're charged with possession of a controlled substance, penalty group 1, 4 to 200 grams. That's a second-degree felony. Range of punishment is anywhere from 2 to 20 years in prison and up to a $10,000 fine. If you have a plea with the state, the court does not have to follow your plea. If the court doesn't follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case?
I did.
Did you understand if the court would grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 20 years in the prison and up to a $10,000 fine?
Yes, Your Honor.
Counsel, has your client been able to provide you with any defenses?
She has, Your Honor.
Do you believe she has a rational as well as a factual understanding of the charges against her?
I do, Judge.
Do you believe she's currently competent and was legally sane at the time of the offense?
I do, Judge.
Ms. Kilpatrick, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No, Your Honor.
Anyone promised you anything other than the plea?
No, no.
Are you satisfied with the way you've been represented?
Yes, Your Honor.
If you're not a U.S. citizen, by entering this plea, you will be deported, denied naturalization, and reentry. Did you understand?
Yes, Judge.
Court will find that defendant has knowingly and voluntarily waived her right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
I did, Your Honor.
According to the plea, punishment is to be assessed at 8 years in the prison. There's a $2,000 fine. The state is opposed to your application for deferred adjudication. They're recommending community supervision. This is to run concurrent with DC 25-9847 out of Gillespie County. Did you understand that to be your plea?
Yes, Your Honor.
Defense and state?
Yes, Your Honor. It is, Judge, yes.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
I did, Your Honor.
By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, Your Honor.
Any such motions?
No, Judge.
Outside the agreement, the state is recommending that your community supervision be for a term of 4 years. There be a TAP evaluation, 200 hours community service restitution, MRT, and DOEP. Did you understand those were recommendations from the state, and the court does not have to follow those recommendations? Then to the offense, how do you plead? Guilty, not guilty, or no contest?
Guilty, Your Honor.
State any evidence.
No objections.
Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
I did, Your Honor.
Again, did you understand you have a right to a jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
I do, Your Honor.
Did you understand that today the state would be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand?
I do, Your Honor.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. The court will defer finding of guilt as you apply for deferred adjudication. Are you proceeding with sentencing?
Yes, Judge.
Well,
Well, we do have
the
an,
thing, I know you're applying for deferred adjudication. The state is opposed.
yes, Judge.
If your client is drug tested today, what are the results gonna be?
You know, been drug tested throughout, a bond. And then hair follicle.
All right, so if you're drug tested today, you're telling the court it's gonna be fine?
Yes, fine.
All right, so I'm gonna go send her to do a drug test.
Sure.
So I'll send her to go do a drug test today,
Okay, Judge.
and then we'll come in.
We'll do defer, I'm just so I understand, what is it that we're judging? My.
So she's supposed to.
If your drug test is negative, I'll grant your application for deferred.
I do have prescriptions that I don't have in mind, is that anything that needs to be?
Oh, they're gonna send you over to do the UA. All right, thank you. All right, she'll be back at 1:30.
This afternoon, Judge. Okay.
Yes.
Thank you, Judge.
All right, Ms. Abrams, can you have her where she goes to do the drug test? Anyone else ready?
Sorry, Judge.
Yeah.
Welcome page. It is.
What does he decide?
Yes, my advice is to go to inpatient.
So he wants to do inpatient treatment?
Yes.
All righty. All right, Mr. Peterson. Court is calling 2022 CR 3176 State versus Henry Lee Peterson. Can I have parties announced for the record
Bridget Garza for defense.
and for the state? And are you Mr. Peterson?
Yes, ma'am.
All right, did you review the document entitled Motion to Revoke Community Supervision with your attorney? Did you understand it?
Yes, ma'am.
Are you the same Henry Lee Peterson who was placed on community supervision in 2022 CR 3176 for the offense of driving while intoxicated third or more on April 13, 2023 for a term of 8 years? Is that you?
Yes, ma'am.
All right, state.
Judge, we proceeding on violation condition number 2, specifically the honor about the 14th day of March 2026 in Berry County, Texas, to defendant Henry Lee Peterson, then and there consumed alcoholic beverages, namely beer, in violation condition number 2.
How do you plead to that?
Guilty.
True or not true? State.
And Judge will be waiving the remaining violations.
Any objections to the waivers?
No, Your Honor.
Did you understand by pleading true to violation of condition number 2, the court could find it true, grant the motion, and sentence you up to 10 years in the prison?
Yes, ma'am.
Knowing that, do you still wish to plead true to violation of condition number 2?
Yes, ma'am.
Court will find violation of condition number 2 true. Could I have the court summary, please? All right, this is what the court is going to do. And we had a conversation, both the defense and the state, and with probation off the record. And you said you wish to be continued as opposed to being sentenced. Is that correct? Are you asking for inpatient treatment?
Yes, ma'am.
All right, the court is going to deny the motion. Alter and amend conditions to include inpatient treatment with state ISF. Probation, do they do drug or just cognitive?
Either. One. So right now, either track judge.
So he's can't do both?
No.
All right, so we'll do cognitive. And then that's going to be followed by ISP. Scram for full term. There's to be no driving full term. And there's going to be 200 hours of community service restitution. And deduct 1 hour for every sober support meeting completed. Otherwise, you're doing the community service hours. Do you understand?
Yes, ma'am.
Probation, is there anything else? All right, you're going to remain in custody until transfer to ISF. Is there anything else?
They should have had 5 years.
Oh, well, do you want the 5 years? Because you're the one who, this was already discussed.
You just wanna do the 5 years?
I'll just stick to 5 years.
Okay, Judge.
All right, so state in defense, the court has entered a legal sentence. Are you asking the court to reconsider?
Desiree Garza stood silently as the judge reviewed her repeated probation violations and failed drug tests. When asked why she kept missing reports, she admitted she knew she would fail the tests. The courtroom turned tense as the judge warned her that ignoring responsibility would destroy her future. Despite previous chances, rehab, and probation support, she continued breaking the rules. Then came the harsh moment. The judge revoked her probation, found her guilty, and sentenced her to 5 years in prison. Before ending the hearing, the judge gave one final warning. Change your life now, or drugs will eventually destroy everything. Comment for the next part.